Hello, everybody. I want to welcome you to the very special webinar that I'm going to be giving today on Special Needs Trust. I'm going to wait a few minutes. We have quite a few of you signing up. I'm glad to see the interest in this subject. This is a subject that is absolutely dear to our heart. All right, we are filling up. I see a lot of you, a lot of familiar faces. We want to welcome you one more time. All right, it is now exactly 10 o'clock. And in deference to all of you who are always on time, I want to begin exactly at 10 o'clock. So we will begin right now. Today, Robert Galliano, part of Kopenberger, I'm going to be talking about special needs trust, but I'm going to be talking about special needs trust in a different way. I will talk about what they are, but what I want to concentrate on today is how distributions from special needs trust how do the distributions affect the benefits that the beneficiaries are receiving. So I will be talking about the purpose of special needs trust. I will address the different types of special needs trust. I will address the first party trust, what it is, third party trust, what it is, pool trust, what they are. And I will talk about the governmental benefits that generally go with individuals who need special needs trust. And then I will talk about another subject, the ABLE account, but I will address California's ABLE account, which is called CalABLE. Why do we have special needs trust? What is the objective? What are we trying to do? Now, all of you who are parents or have family members that are special needs individuals, you know that the objective that we have is to protect and provide for the needs of these individuals with disability and to supplement their benefits that are not received from the government. The ability to have special trusts that permit us to manage the resources and that provide you the ability to maintain government programs for the special needs person is wonderful. Statistically, we're not only talking about children, but we're also talking about adults with disabilities. Statistically, 17% of children between ages of 3 and 17 have some form of disability, and adults also in the United States, they also suffer from disability. There's over 10% of adults that suffer from disability. So when we talk about special needs beneficiaries, we have to include children and adults. The purpose, again, of the Special Needs Trust. It is important that we know and plan for when you are not around and provide a structure so that your child can be self-sufficient when they reach adulthood. We have to take into consideration the governmental benefits that they are receiving, could receive, what benefits they may lose if we do not plan correctly, what programs may seek reimbursement of the benefits, and a lot of times, what benefits could be lost. The set of laws that control special needs is very complicated, very complex. It surrounds itself around federal laws. I have them on the screen. I'm not going to read them, but you can see the complexity of it. A lot of them have to do with Social Security Administration. They have to do with all the Medi-Cal rules that exist in California and all the Medi-Cal rules that are federal. And it is a web of laws that we have to understand and be totally familiar with so that we can prepare the various types of trusts for our beneficiaries. The complexity of these laws are manifested and used in the creation of various types of trusts. There are three basic, I'll call it, types of special needs trusts. The first one is called the first party trust. And the terminology for a first party trust also sometimes is called the self-settled trust. Then we have the other category called the third party special needs trust. And most of the time, we differentiate the first party nomenclature different from the third party trust. We call the third party trust a supplemental needs trust. And I'll explain why we use that distinction. So we have the first party trust, generally called special needs trust, self-settled. Third party special needs trust, generally called supplemental needs trust. And then we have the third category called the pool trust, and that's also what we call self-settled. Now, the term self-settled means that it is funded with the properties of the beneficiary themselves. In other words, the first party trust funded with property that belongs to the beneficiary. The pool trust, self-settled, it is funded with property that belongs to the beneficiary. SNTs, special needs trusts, are used to supplement, but not to supplant public benefits. Let's talk about the first party trust. Again, self-settled. What does that mean? Funded with the beneficiary's own property. There is an age restriction on a first party SNT, and that is that the trust has to be for a beneficiary that is under age 65. A lot of law firms don't understand this limitation on age. They will draft a trust for somebody who is over the age of 65, and the trust will fail. So a first party trust can only be created for beneficiaries under age of 65. Obviously, they have to qualify as being disabled under the determination of disability under the Social Security Act, and the trust can be created by parents, grandparents, legal guardians, or a court order. And recently, the law changed, and it allows the actual beneficiary to create their own first party trust. Now, here's the problem with first party trust. There is a payback provision. And what that means is that if you have a first party trust funded with the money that belongs to the beneficiary, and upon death or termination of the trust, any monies that Medi-Cal has paid for them after age 55 will have to be paid back to the state, because the state becomes the first beneficiary in a first party trust. And there are strict reporting requirements that have to be complied with, and the reporting requirements are to the Social Security Administration and to the Department of Health Services, because they're the ones that manage the Medi-Cal services in California. The first party trust is most commonly used to hold proceeds from litigation. In other words, unfortunate accident occurs, a person becomes injured, they litigate the case, and there's a large settlement, and the settlement then is monies that belong to this particular person who is now disabled. And then Congress, what they did is they created the first party trust to allow then the proceeds of litigation or the proceeds of any type of insurance settlement to be put into this type of trust for the benefit of the beneficiary so they can continue to obtain the benefits that they deserve. So generally, first-party trusts are used for proceeds of litigation and of insurance settlements. Now, I want you to focus on the last bullet on the slide, unplanned inheritance. This is one of the most common errors that parents who have special needs family members make. They never plan to create a special needs trust for that particular beneficiary. And therefore, in their normal revocable trust, they will then leave an inheritance to a beneficiary that is disabled. And the minute that the trust becomes irrevocable, which is upon the death of the less creator sublor, that money then belongs to that beneficiary. And at that point, the only type of trust that can be created for the beneficiary is the first-party trust. And then the first-party trust requirement is payback to the state of California. You do not want to deal with first-party trust if you can avoid it. That a lot of family members do not plan ahead. And then when they die and they leave an inheritance to a disabled individual, they are then stuck, forced to have a first-party trust with payback provisions. There's another term that I want you to be familiar with, and you may not have heard about this. It's not very common, but it's called the Medicare Set-Aside Trust. What is the Medicare Set-Aside Trust? This is an interesting type of trust because it generally is only implemented together with a first-party trust, and that happens to be a type of trust that is created to reimburse the government for any future medical costs related to the injury that perhaps the worker generally has done in workmen's compensation cases, the injury that the individual had at work. At some point in time, they may need Medicare as a government benefit, a government insurance program, and therefore the MSA trust is created to set aside some of the benefits for future medical costs to reimburse the government for any future Medicare costs that they would have to pay in the injured person's lifetime. So it's generally created as part of a settlement in personal injury or workmen's compensation cases. So this is a unique type of trust that is created under certain specific, I'll call it circumstances, generally, again, personal injury situations, workmen's compensation cases. And again, the purpose of the MSA is the MSA will hold a portion of the settlement and set aside for future medical expenses otherwise covered by Medicare. All right. We're going to be talking about third-party trust. And I see that somebody raised their hand, and what I would like to do is to hold any questions until the end of the presentation, because a lot of times the questions that are raised will be answered throughout the presentation. So there's a Q&A, and on the bottom of your screen, there's a Q&A location where you can write your questions that we can answer at the end. Right now, what I want to talk about is the third-party trust. Now, again, I mentioned earlier that the terminology that we use is for the first-party trust, we call it special needs trust. Then for third-party trust, we call them generally supplemental needs trust. So why the difference? They both pretty much accomplish the same thing. So why do we have a different nomenclature for the first party and the third party? And here's the reason why. We have to submit trust to Social Security Administration. We have to submit trust to the Department of Health Services, they have attorneys. They have a bank of attorneys. They have a bank of clerks that review these trusts for correctness. And their job, quite frankly, is to deny. A lot of you perhaps have applied for governmental benefits, VA benefits, or other type of benefits, and you know that there's a long list of red tape that we have to go through in order to get those benefits. So generally what we're trying to do is, if we provide a trust for review, for example, to the Department of Health Services for medical benefits, and the title of the third-party trust, for example, is called Special Needs Trust, the clerks, we have found that they will look then for a payback provision. Because remember, the first-party trust has to have a payback provision. So as the clerk picks up a trust for review and the title reads Special Needs Trust, they may be looking for that payback provision. And if they cannot find it, they may deny or declare the trust to be invalid. So when it's a third-party trust, in order to provide easier, I'll call it identification as to what it is, we call it a supplemental needs trust. So third-party supplemental needs trust. When I'm talking about third-party, I mean that the money that is put into this type of trust belongs to somebody else, a parent, a grandparent. Generally, it is funded with money that is left as an inheritance to a disabled beneficiary. Third-party supplemental needs trust funded with other people's money, no payback provision required. I'll say it again, no payback provision required. And also, it is not controlled by a lot of the federal regulations that control the first-party trust. No age restriction. If you recall, there was an age restriction on the first-party trust. Remember, 65 years of age. Third-party trust has no age restriction. The third-party trust can be revocable or irrevocable. Sometimes it's best to have a revocable trust because circumstances may change and the family members may want to alter the terms of that particular trust, or sometimes you want to start off with making it irrevocable. So the consequences of revocable or irrevocable is the management capability, the ability to change it, and also there's some tax issues in the sense that if it's revocable, then the benefits still belong to the creator, and then any income tax issues belong to the creator, the settlor of the trust. If it becomes irrevocable at the beginning, then you have to get a tax ID number, and then the trust becomes then the payor of any tax issues. So again, advantage of a third party, no payback, no age restriction, and there is no mandatory reporting. The use of a third-party trust is generally when parents leave assets to a disabled beneficiary. And the terminology in a revocable trust should always be that the parents are leaving X number of dollars or a percentage of the estate to Jack's supplemental needs trust. So the terminology within a revocable trust, if you're leaving an inheritance, is to leave it to the beneficiary special needs trust. It can be done through a revocable trust, RLT, revocable living trust, or through a will. The most common mistake, and I'll say it again, parents fail to provide a special needs trust, a supplemental needs trust for the beneficiary. They don't know to create one in advance. And when they die, they're leaving an inheritance to a child. Remember, that becomes the first-party trust, and there's payback provisions and reporting provisions. It's not the best type of instrument to have. All right. The other type of, I'll call it special needs trust, is called a pool trust. What is a pool trust? A pooled trust is also what we call a self-settled trust, in a sense that it is also created with the money of the beneficiary. This type of trust is established and administered through a nonprofit association. Think of a pooled trust, not the same analogy, but a lot of people, for example, are used to mutual funds. Mutual funds, for example, you have an account, you invest money into a mutual fund, you own part of the fund with other people. In this example, you pool the benefits for that particular individual. They have their own account, but it's pooled with others to make investments and so forth. And so you have a separate account, it's pooled with other accounts to make investments, managed by a nonprofit association. But this type of trust also has a payback provision. So when would you want to use a pooled trust versus a first-party trust? Well, remember, the first-party trust has an age limitation. If the beneficiary is over age 65, and there's a need for what we have called the self-settled trust, the pooled trust has no age limitation. So that's one of the advantages of the pooled trust. In addition to that, because there's no age limitation, also it is managed professionally by the organization, the nonprofit organization, and they a lot of times can manage the estate or the trust with lesser administration fees than a first-party trust. And a lot of times, a lot of families cannot find a trustee for the first-party trust, and therefore the use of a pooled trust, because they have a administration department that can manage these type of trusts. That is why these are selected. So at this point, we talked about first-party trust funded by their own money, but it has a payback provision. Age limitation has to be under age 65 for the beneficiary. Then there's the pooled trust, self-settled, funded with beneficiary's own money, no age limitation, but there is payback. So again, I am repeating the biggest mistake that parents make, and that is they fail to prepare a special needs trust while they are alive and well. And a lot of you already know this. Not having a special needs trust may absolutely cause the loss of benefits, because a lot of these benefits that are available to beneficiaries, a lot of these programs, and I will discuss them in a few minutes, are based on amount of assets and income that they or may not have. And it would be a travesty to know that you work hard all your life to leave a special needs beneficiary money, and because of the lack of planning, number one is they're going to lose all the benefits that they originally had, and not only that, but the government can wind up inheriting the money instead of it going to the beneficiary upon your death. It is just a terrible situation, and we see this often in our office. All right, I am going to be talking a little bit about benefits. There are two different categories of benefits. The one type of benefit, which I will call entitlement benefits. What do I mean by the word entitlement? Well, the word entitlement, that's a term that is used in a lot of the legalese, but the word entitlement is that, hey, you worked, you paid taxes, you're entitled to it. You don't have to qualify income or asset-wise. You're entitled to it. You worked. That's what the word is, entitlement. So there's a lot of benefits that you're already entitled to because you already put in the time or you already qualified other ways. And generally, these entitlement benefits, like SSDI, what does that mean? Social Security Disability Insurance. There's no income and asset limits for that. This is the Social Security payment that you get when you're disabled. You get hurt at work or you have a disability, Social Security disability income. This is SSDI. There is no income asset limits, but you must have worked a certain amount of credits, generally at least 40 credits to be able to be available. And also you have to qualify as being disabled under the disability determination under the guidance that's put out by the Social Security Administration. So if you have worked the required number of work credits, hours, and you are disabled, you are entitled to apply then for cash assistance under the SSDI program. The SSDI program is an entitlement. You're entitled to it. And also the medical assistance that you get when you are on SSDI is that after you have been on SSDI for 24 months, you will automatically be entitled and eligible to receive Medicare for Part A and Part B. I want to switch now to the other type of benefits. These are called needs-based benefits. Needs-based benefits really means is that you have to qualify income and asset-wise to obtain these benefits. You're not entitled to these. You have to qualify for it. Under these type of benefits, the cash assistance program is the SSI program. Currently, the amount of money for 2023 that the federal government pays for a single individual under the SSI program is $914 a month, and for a couple is $1,371 a month. In addition to cash assistance under the SSI program, there's also what we used to call food stamps, which now called CalFresh, and housing subsidies. They generally go by the term Section 8. And what is the medical assistance? Medi-Cal. All right, why have I made a distinction between entitled benefits and need-based benefits? Let me go back to that slide. Entitled benefits. These type of benefits, for example, the SSDI, you generally do not need a trust for this. You do not need a special needs trust. You don't need a supplemental needs trust for these type of benefits. Now, a lot of times you can have a trust and create a trust because of management issues, but it's not a requirement to have a special needs trust or a supplemental needs trust if you're receiving SSDI benefits. Now, there's a confusion with reference to terminology. There are several types of Social Security payments. There's the kind of Social Security payments that you get generally when you reach the age of 65, retirement benefits. And on the screen, you can see SSDI, disability income payments. And then on the other slide, SSI, supplemental security income. So what type of benefits is the beneficiary receiving? It is critical and important to be able to differentiate and understand what type of benefits are they receiving, because the difference in benefits that they're receiving can dictate the type of planning that needs to be done. So again, entitlement benefits, you are entitled to them. Needs-based benefits, you have to qualify for them. All right. Supplemental security income. This is where it gets interesting. SSI is intended to pay for two items only, two, and they are the beneficiary's food and lodging, nothing more. And there is now a move in Congress to eliminate the food requirement, and therefore SSI, we think that it's only going to be for the payment of lodging, shelter. But right now, SSI is intended to pay for the beneficiary's food and shelter and nothing more. Now, SSI in California for 2023, if you look at the number that I have on the screen for a single person, $1,133.73. Well, wait a minute. On the previous slide, you had $914. What's the difference? The difference is that California provides an additional benefit for SSI recipients that increases the amount that a single person can have in California up to $1,133.73. And if it's married, $1,927.62. So California has an additional amount of money that it can pay to the SSI beneficiary that increases the benefit then to these higher numbers. All right. This is a very critical slide that I want everybody to really focus on. Very important. California is one of few states that is considered, the terminology, I'm not going to go into the details of the rules and the laws and so forth, but I want to just tell you that California is classified as a Section 1634 state. California is a Section 1634 state. What does that mean? Why is that important? Here's why. Because that particular law, federal law, the government has worked out with certain states, California being one of them. And the fact is that if an individual is on SSI, if an individual has qualified for Social Security income, if they are receiving at least $1 of SSI, then they will be receiving the full scope of free Medi-Cal automatically. I'll say it again. If you are an SSI recipient in California and you have at least $1 of SSI, then you are entitled to receive the full scope of free Medi-Cal automatically. Why do I make this point? Because we don't want to ever distribute monies to a beneficiary that will eliminate them from receiving SSI, because if you lose SSI, you will lose Medi-Cal. That's the importance of this slide. Let's talk about SSI income, because this is really also something that I would like all of you to have a general understanding. First of all, remember that SSI income is earmarked by the government to pay for two things: food and shelter. So the government does not want you to pay for the beneficiary's food and shelter, because the government then will say, wait a minute, we are paying for the food and shelter. Why are you paying for the food and shelter? So if you're paying for the food and shelter, why should I, the government, be paying for the same thing? So now we are going to reduce the benefits because you are paying for food and shelter. That's the logic. Remember, SSI pays for food and shelter. You don't want to pay for food and shelter because that is what's going to impact some of the benefits. So what does Social Security deem to be income? Well, there are three categories. The first category is called unearned income. What is unearned income? Well, what if you have a CD at the bank and the CD is earning, I'll be generous, 4%? 4% was earned, not by you, it was earned by your deposit. So that is generally what is unearned income. It's income, that's something that you had, like a stock, earned income, unearned income. You didn't work for it. The next category, earned income. That's when you and I grab a shovel, go out of the backyard, we work for somebody, we clean up the yards. We work and earn the income. Third category, in-kind support and maintenance. That is where a lot of people make the mistake. It's easy to understand unearned income, simple to understand earned income, but when it comes down to in-kind support and maintenance income, what is that? Well, if I, for example, give a disabled child $100 cash, that's pretty much considered a gift, I understand, but it's money given to them. Let's assume that that money was for the child to buy shoes. What if I buy the shoes and give the shoes to the beneficiary? I am providing the same benefit, the shoes, that I'm providing the benefit in kind, the shoes themselves, not the cash. So in-kind support and maintenance is a way to provide for support and maintenance by not necessarily providing direct cash to the beneficiaries. So what we want to do is to be careful as to what kind of monies we provide the beneficiary, because if we do not distribute money correctly, the income that is provided to the beneficiary will reduce the SSI benefits. SSI income is earmarked to pay for food and shelter. We can pay for other things that are not food and shelter, but we do not want to pay for them by providing cash, for example, to the beneficiary. We want to provide in kind, buy the television set, buy the shoes, buy the clothing. I say clothing because several years ago, clothing was on the list that we could not do. That's gone away. So the point I'm trying to make is that the distribution of special needs trust, supplemental needs trust, may reduce SSI income because we need to understand how to distribute the monies without reducing benefits. All right. This is an important point because it comes up fairly often, and I will give you the scenario. Number one is, let's assume that you have a disabled beneficiary who has a special needs trust. And let's assume that that beneficiary is earning, let's say, $800 of SSI. That's the income that they get. They're receiving $817 in SSI income. But let's just say that a family member wants to place the beneficiary in an assisted living facility or in another facility. But the rent for that facility costs $1,200 a month. Or maybe it costs $2,000 a month. Maybe it costs $6,000 a month. How in the world does the beneficiary who only has an income of $800 a month pay for that type of lodging? It cannot. And remember, the big no-no is that SSI pays for food and lodging, right? So here we have a problem in the sense that we have a beneficiary who only makes $870 a month, If the brother wants to put him in a facility that another lodging location where the rent is going to cost over $5,000, $6,000 a month, how can that happen? Don't you have a conflict then? Isn't there a conflict with what I just said? You can't pay for lodging because it's going to impact the benefits. But yet the beneficiary can only pay $100. So how do you do it? Very important for you to understand this. All of these rules, complicated rules, unlimited amount of rules, super complicated. There's a set of rules that are contained in a program operation manual put out by the Social Security Administration. The general term is called POMS, P-O-M-S, Program Operation Manual. That's where all these rules are. So there's a very interesting rule that I need you to understand what that rule is. There is a rule that is called the presumed max value PMV rule. This is the saving grace. And that is that this particular rule says that the maximum amount that the beneficiary's benefit can be reduced is limited to 1/3 of the federal rate that they are paying for 2023, $914 plus $20. The maximum deduction that can be made of the beneficiary's benefits of SSI is $324.66. So the brother could pay the rent, $1,200, $3,000, pay for electricity, pay for taxes, and the most loss of benefits to the beneficiary under the PMV rule would be $324.66. So there is a magic rule that limits, caps the amount that can be lost under the circumstances for paying for the shelter. Even though the rule says that the SSI is for food and shelter, there's a way around being able to pay for shelter by using the cap of the PMV rule. All right. One other magic bullet. Have you heard of the ABLE accounts? I am going to simplify. ABLE accounts are similar to a 529 account. A 529 account, a lot of you may have some for other beneficiaries, for example, children or grandchildren. 529 account is an account that you open for educational purposes for the person. And ABLE accounts is something that was implemented by Congress to provide the ability to have an account for people with disabilities. And an ABLE account is an account that's designed for individuals with disabilities. And this ABLE account allows the beneficiary and, for example, other individuals, parents, uncles, to transfer, deposit into that account up to $17,000 per year. Now, the $17,000 number should trigger in your mind that happens to be the gifting amount that you can give per year in 2023. You can gift up to $17,000 per person per year in 2023. Well, that $17,000 number is used also in the ABLE account. CalABLE is the California ABLE account. And everybody, the beneficiary can transfer $17,000 into the account. Parent can transfer $17,000. A friend can transfer $17,000. And that money in the CalABLE account then can be available for the beneficiary. And it can pay for allowable expenses. It comes out income tax free. Any money that comes out is not counted as income against benefits. And it's a way to pay, for example, for rent with no need to worry about the PMV rule because it is not counted as income. Now, in order to be eligible to open an ABLE account under current law, the beneficiary's disability has to have occurred before the child reached age 26. Now, in the year 2026, Congress just passed a rule that says that after January 1, 2026, the disability has to have occurred prior to the age 46 of the beneficiary. So there are some individuals that currently cannot have an ABLE account because the disability occurred after age 26, but in just a couple of years, they will be able to qualify for an ABLE account because the law will change. Think about it. It's going to be a fund that people can contribute, that the money will come out income tax free to pay for benefits that would be almost, the allowed expenses are almost anything, and one of them would be rent, and the income is not counted. It's not going to take away from any of the benefits, and you don't have to worry about the PIV. You don't have to worry about all these other restrictions. And it's a fantastic tool. All you have to do is go on the internet, look under CalABLE accounts. It will tell you everything about it. This is a wonderful, wonderful tool. It is a tool that it has to be used, in my opinion, when it can be used together with the special needs planning. Special needs trusts and ABLE accounts, they go together. In conjunction, the planning can be done so we can have ABLE accounts benefit, special needs benefits, and so forth. So it's just another tool to be able to use for people with disabilities in the structure of a special needs trust and ABLE accounts. Again, ABLE accounts, income and resources, third-party contributions, not income, $17,000 per year. CalABLE interest and distributions to beneficiaries, not income. Special needs distributions to CalABLE, not income. The first $100,000 in the CalABLE account will not impact any SSI benefits whatsoever. If the amount of money that goes into the ABLE account goes over $100,000, then the SSI benefits are basically cut off for a while until the $100,000 in the CalABLE account is reduced under $100,000. But that's $100,000. It's easy to keep under the $100,000. And the question is, how much money could you put into an ABLE account? Well, the amount of money that you can put into an ABLE account is the amount of money that you can put into a 529 account. And in California, that's over $500,000. So if you have not been thinking about ABLE accounts, I want you to think about ABLE accounts. ABLE accounts is another tool to work with the special needs planning. Well, when we meet with potential candidates on this type of planning, we have to understand, first of all, what kind of benefits are they receiving? As I mentioned earlier, if they're receiving SSDI and Medicare, maybe there's no special trust requirements. If they're on SSI and Medi-Cal, S&T types of trusts are required. Where's the money coming from? Is the money from awards, parents? How much money? What is the age? Under 65, over 65? What are the alternatives to special needs trusts? Is the amount of money they receive maybe from an award such that you could spend down and purchase exempt assets? Is it possible that maybe you don't need to have a special needs trust? So these are the things that are considered whenever we have a meeting with the client. Now, I'm going to interject something here. We have another webinar on this, and I will be giving it probably latter part of June. I want you to be aware of something, and that is that when you have a beneficiary on SSI and Medi-Cal, the income and asset requirements are totally different. The SSI income requirements, an SSI, an individual can only have $2,000 worth of assets. SSI asset requirement, you can only have $2,000 of assets. For Medi-Cal, currently the individual can have up to $130,000 in assets, and in 2024, there will be no cap on the amount of income the person can have. So you have two distinct rules, set of income. SSI rules, limited to a certain amount of assets you can have, $2,000. Medi-Cal in 2024, a limited amount of assets that you can have. SSI income rules are different than Medi-Cal income rules. So you wind up with two competing platforms that you have to navigate through and understand the type of trust that you have to have, and you have to manage the particular trust to qualify the beneficiary for SSI and Medi-Cal. Critical to understand. Secure Act. We have webinars in the Secure Act, but I want to bring this to everybody's attention who has a special needs trust, and that is that the Secure Act that originally the number one that was passed a few years ago, that was again followed by Secure Act 2.0. What is the impact of the Secure Act on special needs trusts? Well, the Secure Act did the following, and generally the major impact was the following, in the sense that if you inherited an IRA, generally for individuals who did not qualify under the 5 exceptions, the individual then had to take out the money from the inherited IRA over 10 years. And during the first 9 years, they had to take out the required minimum distribution every year. Prior to the Secure Act passing, a non-spouse could take out the distributions over their lifetime. They could stretch out the payments from the IRA over their lifetime, minimizing income tax liability, maximizing the growth of the account because it grew tax deferred. The Secure Act limited that. It said, hey, wait a minute. You are now required to take it out within 10 years. But the Secure Act provided exceptions. If you're a spouse, if you're disabled, you have a disability, you're a minor child, you're someone 10 years younger than the owner of the IRA, then you are then qualified to continue to take the payments out over your lifetime. You're called an eligible beneficiary, and a special needs child would qualify as a disabled person who then could qualify to continue to take out smaller payments from an inherited IRA over their life. Therefore, we have to be sure that we have a trust that is now called a Secure Act Special Needs Trust that has all the proper verbiage and so forth of the Secure Act that can handle then inheriting IRAs so they can qualify under the rules of the Secure Act so they can continue to take the distributions over their lifetime as opposed to over 10 years. Generally, if you're leaving an IRA that's greater than $200,000 to a special needs trust, then that trust should be updated to have what we call a Secure Act Special Needs Trust. So what's the challenge? You as a trustee, you have monumental responsibilities. You have to understand what the impact of the distributions are on the public benefits that the beneficiary is receiving. You have to understand the management. You have to understand the tax planning. You have to understand the reporting. You have to file tax returns. You have to report to the Social Security Department. You have to report to the Department of Health Services. There's redetermination every year. You have responsibilities and duties. You're a trustee. You have to understand what these responsibilities are. S&T planning is crucial, important. You have to understand. You have to stay current with the rules. Whoever you work with has to understand the types of trust, the creation of these trusts, the funding. You have to be aware, make you aware of what's going to have to happen when you have one of these trusts. It is a complicated planning, I'll call it, process that has to occur. So how can we help you? Well, we want you to consider what's most important to you. Determine your responsibility as successors, your responsibilities as beneficiaries, and discuss and plan these things while you're alive and well. Remember, being alive is fine, but you have to be alive and well, have the cognitive ability to make these decisions. And you also have to make sure that you have your plans updated and reviewed on a regular basis and make sure that you're current, particularly if you have special needs beneficiaries. It's critical that you understand how these rules change and how they may impact these beneficiaries. For those of you that have been with Kopenberger for a long time, you understand and you realize that we've been around since 1979. We just celebrated our 44th year in business. We have 8 full-time attorneys. We specialize. We don't do divorce. We don't do bankruptcy. We don't do criminal defense. We only do one thing. And that is we do everything that has to do with estate planning, trust administration. We have a business and tax department. 8 full-time attorneys, 2 attorneys of counsel, over 350 years of combined attorney experience. We talk to each other all the time. We talk about the various cases. We strategize with each other. And half of us are certified specialists in estate planning and trust law by the state of California. Half of us have advanced tax degrees. And we have the most wonderful, qualified, educated, supportive staff that anybody could ever want. All the individuals that support the law firm are fantastic, highly qualified support staff, and no one can function without the support of everybody in our office, and we all work together as a team. We have appointments in the office, we have appointments by Zoom, we have appointments by phone calls, and I just want to thank you, and I am running out of time, but I will try to answer a couple of questions if I can see them. But you will be receiving an automated phone call and today or tomorrow asking you if you're interested in setting an appointment to discuss what we discussed today. So let me see if I can look for. This is where I get lost, quite frankly, trying to understand, and I cannot find the questions and answers. So what I'm going to do is I'm going to say that all of you have questions. All you have to do is to write to me or call me through the company. I'll be more than happy to discuss whatever questions you may have. And I want to thank all of you for attending. I want to thank all of you for being with me. And I hope that you found interesting what we had to discuss. Thank you so much. And you take care of yourselves.